Good morning, everybody, and welcome to another episode of North Alabama Law Review presented by Johnston and Weston. I'm your host, Shauna Hill, and today we have joining us Mr. Mickey Gentle and Mr. Christopher Weston. Good morning, guys.
Good morning.
Thank you for joining us today. So today we're going to talk about something that I'm sure a lot of people have questions on it, and it's what happens when we do not agree with the decision of the court, also known as the chance to appeal something. So, Mickey, just to kind of start off the conversation, can you explain exactly what, in a deeper detail, what an appeal is and what it does and does not do in the legal world?
An appeal really boils down to the fact that you're charging an error to the trial court. So you go into trial and you try your case and you wish to enter an appeal to an appellate court, you're basically telling the appellate court that the trial court made a mistake in some way or another. And so you're going to take that case to the appellate court and tell the court why you believe the lower court made a mistake, and then they will review it and they will make the determination that the trial court did or did not make that mistake. It is strictly a review process. It is not where you would take up new evidence or have another trial, and they just simply are reviewing evidence, and the court makes the decision that there was or was not an error made.
Now, if someone is ready to start the appeal process in Alabama, what happens? Like, what does that process look like when they open the appeal?
And a lot of this boils down to which court we're going to, because we have, at the trial court level in Alabama, you have a district court that's a trial court, and some appeals can go from there to the appellate courts in Montgomery. A circuit court is another trial court that we have, and appeals can go to the appellate courts in Montgomery as well. If we're talking about a criminal matter that can be appealed to the appellate courts in Montgomery, those will go to the Court of Criminal Appeals. If we're talking about a civil case that is being appealed, it will go to the Court of Civil Appeals, and those are the two intermediate appellate courts that are in Montgomery. There are some civil cases that must be appealed directly from circuit court to the Supreme Court. Now, if the appeal in question falls under any one of those three categories, then it's a matter then of filing a notice of appeal with the trial court, and that gets the ball rolling with the appellate courts in Montgomery.
Now, Mickey, my understanding is that, a lot of family law cases can go from the district court to, an appellate court in Montgomery. But, doing a lot of the trial work myself, too, is that there are, usually if it's a small claims court or a district court, it will be appealed, and this is either criminal or civil, it will be appealed to circuit court first for a new trial. But there are some exceptions. Can you tell me what those exceptions are? Because they're not areas that I usually practice in. Right.
So a small claims case is held in what we call the district court that I mentioned a while ago. And an appeal to that would, in fact, go to circuit court for what's called a trial de novo, which is a very different type of appeal, because essentially a trial de novo is almost like a second bite at the apple, you might say, where you're actually going to try that case in front of the circuit court as if the other one had not happened. Certain civil cases at the district court level that are not small claims can go that route as well. Now, in Alabama, a lot of the juvenile courts are held in front of a district court. It's not required that it be in front of a district court, but a lot of counties do that. And if you're talking about a juvenile case, then that can be appealed to the intermediate court in Montgomery directly. So if you have what we call a dependency case that's in the juvenile court, and you file an appeal to that, that will go to the Court of Civil Appeals. And if you're talking about a juvenile delinquency case, that will go to the Court of Criminal Appeals. And so that's the exceptions there that you're referring to there, the cases that can go directly from the district court to the Court of Civil Appeals or the Court of Criminal Appeals.
Okay. I'll tell people at home, too, understand there's a lot of reasons that you may disagree with the trial court. It is not just that a trial court has necessarily done something wrong. And Mickey, I'm going to leave explaining the levels of error to you, obviously, and something that is where they're allowed to, in appellate courts, allowed to look at it de novo versus having to look at it, in an abuse of discretion. I'll let you discuss all of that. You know that far better than I do. But just to kind of talk to people at home is the way that this works is that it's not just losing a trial. It's not just winning a trial. It can be the way you lose or win a trial, something you really needed or wanted, or, you can win the entire case and lose a piece, but really feel that piece was a big part of what your recovery should have been. It's not just about purely winning and losing. At the same time, we see a lot of appeals, and I've filed several. Fortunately, I don't lose too many of those, to be perfectly honest with you, but in the motion side, where it's either a motion for summary judgment where a trial judge may believe something was a matter of law when in actuality it was a matter of fact, or when they interpret the law one way and you don't think that law should be interpreted in that manner. We see this on the criminal side a lot when it comes to suppression motions, and it comes to whether or not something was a violation of somebody's rights for police to do a certain thing. And like I said, a lot of times at the trial court level, it will be during motion practice. And so for the people at home is understand we have that statement in law that reasonable minds can and will differ, okay? And sometimes you'll have a trial judge who's very, very versed in one area of law throughout their career and is in something new. That happens sometimes. At the same time, you can disagree with the judge and also just be wrong. Your interpretation may not match, or it may be a novel issue that has come up. It can also be a looking at the facts and how they apply to the law in a different way, whether at motion or at trial, or a lot of times in damages. So, you can win a case and get damages, and an opposing counsel will argue that, punitive damages are unconstitutional, or they're too high, or they violate the statute or whatever. And a judge can either leave them where they are or lower them, and you may appeal that issue. We've seen that, or if it's a jurisdictional issue. So understand for the folks, just because you don't get what you want at during a motion or during a trial, or even if you do get what you want and the other side appeals and you go, well, why would they appeal? The reality is that very seldom in law is something cut and dry, and you may have a disagreement with your trial judge. The important thing to do is that as long as your side was argued with veracity and with assertiveness, being thorough. Just because you don't get the result that you want does not mean that there has been some failure or some corruption on the part of your lawyer or the judge or a prosecutor or an opposing counsel. Understand, people legitimately do look at things different ways, and having an impartial arbiter, basically a judge, that's why we have that system, is to be able to deal with these kinds of discrepancies without violence.
So when someone wants to start the appeal process, how long do they have after the initial court ruling to start that process, and what does that process look like?
If the appeal is taken from a district court, then you've got 14 days to file that notice of appeal.
Really quick then.
Very quickly, yes.
Quickly.
Now, is that calendar days or is that business days?
It's calendar.
That's what I thought.
Oh, wow.
Okay.
It's only 2 weeks.
Right.
Mm-hmm.
Okay.
And then if it's from the circuit court, you have to have 42 days to file that appeal.
What about if they file like a motion to alter, amend, or vacate, or to change the judgment?
Post-trial motions that are timely filed will actually stay that ruling and the time to file the appeal. So you've got the 42-day window that I referenced. You've got the 42 days that will start running at the time that the final decree is handed down. But if you file a post-trial motion under certain rules of procedure, then you actually can stay that time, and your 42 days would start running if and when that post-trial motion is denied.
So no lawyers ever filed a post-judgment motion just to extend that time before, have they?
Of course not.
Never. It's never happened. Never happened to buy that extra time. Never occurred.
So when the appeal process gets started, what is the very first thing as an attorney that you're going to do in the appeals process?
Yeah, Mickey, how do we do it, man? How do we do it? Tell us how we do it.
There's the notice of appeal that I mentioned earlier, and then there's a docketing statement and a transcript purchase order.
What's a docketing statement? Help us out, Mickey. Tell us about it.
Law 101.
Yes, well, the docketing statement is just a lot of the information about the parties, where they, you got the appellant who actually has filed the appeal. It identifies that person. It identifies the appellee, who is the one against whom the appeal is brought. If there are other people in that action, then it identifies them. It identifies who the lawyers have been in there. It identifies the issues and what you are actually appealing in the case.
See, I find this interesting because I don't deal on the appeal side very much, unless it's going for like a trial de novo, from one court to another. Mickey handles all of this at our firm, and so actually, Mickey, I'm actually kind of sitting in the shoes of the viewer right now, because if I win, great. Rare loss, I just throw it at Mickey as hard as I can and go, Mickey, make this happen. And Mickey is gracious enough to put up with me. But the bottom line is I'm kind of sitting in the role of the viewer at home. Like, I'm wondering about some of this stuff. So, like, you do your notice of appeal, obviously. I've dealt with those. The docketing statements make sense. It's basically an informational sheet. And then you're dealing with your transcript request. But there's an entire different set of rules of civil procedure or appellate procedure. Right. Like, it's an entirely different, I don't want to say code book, but it's an entirely different rule book.
Right.
So you have your trial rules, and then you have your appellate rules. So, for those sitting at home, kind of wondering about this stuff, give us a little guidance on, what you're looking for as somebody who actually writes appeals. Like, obviously everything I've ever done to clean my record, obviously that's the standard, right, Mickey? He's looking at me dead-eyed. I don't blame you, Mickey. I don't blame you. No, it's definitely not. But just kind of walk us through that, if you don't mind, because this very much interests me.
Well, and I guess, too, a lot of times it's going to be a matter of how did I get the appeal. If the trial has already taken place and I was not the attorney of record in that case, then I'm bringing the client into the office. I'm asking my questions about what happened at the trial. What was the gist of why did you bring the action in the first place, if we're talking about a civil litigation matter? Why did you bring that action in the first place? And what were you hoping to accomplish when you went to trial? And what is it about the matter that you feel to be erroneous? And of course, in walking through that with the client, I'm asking other questions that might be specific to the case to help me understand what they would like to accomplish at the appellate level. And so,
Mickey, we want to win, man. We want to win.
But what I'm getting at here is how do we win?
Yeah.
So like, if they're seeking to get a trial court reversed, then I need to be able to understand the gist of the trial so that I can say, well, here's what I believe to be the error. And it might be an error based on what case law says, a disagreement over how that should be interpreted, the disagreement over the interpretation of a statute, a particular rule of civil procedure, a particular rule of evidence.
So what are those different standards? I know some of them, obviously, just me and you having spoken. But just so everyone at home knows, so basically, you guys come to us lawyers when you're like, hey, this has gone wrong, but I was right, and, I need to deal with this. When lawyers think we're right about something and we didn't get our way, we go to Mickey and go, Mickey, I was right. This is garbage and I don't like it. And so Mickey's knowledge of precedent, is, I would argue, second to none. And so when I come down the hallway and throw down a file and go, Mickey, but I should have won, man, like, do something. What are the different standards of review that an appellate court can do?
Yeah, and there again, it kind of depends on what you're appealing. You know, if you're talking about certain denials of a review on a dispositive motion, then you have in some cases what we call a de novo review, where there is no presumption of correctness there, and the appellate court just looks at the argument that's made and determines that you're right or wrong by charging error in the denial of that post-trial motion or in the granting of a dispositive motion. And I'm sorry, I had a slip of the tongue there. I said granting of a post-trial motion. That's not what I meant to say. What I meant to say was if you have a dispositive motion, there's the de novo review there. If you have the denial of a post-trial motion, there's going to be another standard there, which is what we call the ore tennis rule, where there is a presumption of correctness there. Now that happens in a non-jury trial where the judge is there in the trial court, and that judge is able to watch the witness's demeanor. That judge is able to listen to all the vocal fluctuations of the witness, and with that, hear the evidence that's presented, listen to the facts of the case, and apply all that together and come up with some sort of a decision. They are afforded a pretty good weight of discretion in that case. And that rule will say that the appellate court will not overturn that decision unless it can be demonstrated that the judge has abused his discretion, or the legal buzzwords, you prove that the ruling is plainly and palpably wrong. In jury cases, there's a presumption of correctness there that the weight of the evidence is such that a reasonable jury should have ruled the way that the jury ruled, and that's the review that's looked at in a jury trial, civil and criminal.
All right, well, let me see if I can put this and compartmentalize this into my brain. So basically you have more or less, just kind of generally speaking here, 3 different standards essentially. So one is when you're dealing with, for those of you at home who don't know, a dispositive motion is like a motion to dismiss, a motion for summary judgment. What that means is that somebody is arguing that, oh, this doesn't need to go to trial. Judge, you can make a ruling right here and now just on the basis of the law, just on the basis of what's right in front of you. Assume the other side's right, but even if you assume they're right, they're still wrong and they can't go to trial. That's what that is, okay? So for summary judgment, or a lot of times with a motion to dismiss, they're saying that even if they're right, they're wrong. If that goes up on appeal, then basically there's no presumption given that the trial court was right. The appellate court looks at it with fresh eyeballs and says, okay, is this right or wrong? And the reason is because it's interfering with a trial right, a right to go to trial and be heard on the merits of your case. Is that right?
Right.
And then the next level is like you've already gone through trial, and what you're dealing with there is like, okay, well, you got your evidence heard. Now the trial court has discretion, and now we're going to look at it and say, well, now we're going to assume the trial court or the jury was right because they actually did hear all of the evidence. And so you've got to show something pretty egregious for us to mess with that, because you got heard and someone said you were wrong. Is that right?
Right.
And then kind of the third level that I've ever seen are things like where a judgment is void, like something like subject matter jurisdiction, like you're ruling on 2 pieces of property from Colorado that had nothing to do with Alabama. You didn't realize it had nothing to do with Alabama. You put out a ruling and the Supreme Court goes, no, you can't do that. That's, you can't touch that whole issue. And that is just literally not, that's de novo. Again, it's like, did you have the right to do this or not? Right. Am I framing that correctly in my brain?
That's pretty much it, yes.
Okay, cool.
And
now, I'm sorry, for your everyday viewer, we hear Supreme Court is the highest law of the land that you can go to. You mentioned different courts like district court. So if you file an appeal with district court and you still don't agree with that outcome, can you appeal it again to Supreme Court?
The district court is actually a trial court. There's not an appeal taken to them.
Okay.
If you're taking an appeal to the appellate courts in Montgomery, then most of the time it's going to go either to the Court of Civil Appeals or to the Court of Criminal Appeals, and certain exceptions that do mandate filing directly with the state Supreme Court. and most of American law is set up to have that three-tiered system. You have the trial court, an intermediate appellate court, and a court of last resort. Which in Alabama you have the trial court, the district courts, and the circuit courts. Then again the intermediate appellate courts, or the court of civil appeals, and court of criminal appeals. And then the Alabama Supreme Court is the highest court in the state. And at the federal level, you have the trial courts. Those are called district courts. And then the intermediate appellate court is called the Circuit Court of Appeals. And then the highest court in the land is the U.S. Supreme Court.
Thank God you know all that.
Yeah. So for those of you who want to hear about the latter, so you have district courts, which are also small claims courts, okay? Now, excuse me, they cover small claims cases. So you have district courts, which again are any dispute up to $20,000. Small claims courts are any dispute up to $6,000. And those are both heard at the district court level. Usually you can appeal those for a brand new trial to circuit court, which is another trial court with a very few exceptions that Mickey's already laid out. Then if at the circuit court level you do not get what you want, you can then appeal basically on briefs and motions to say there was either a matter of law issue or a factual issue. That goes to the intermediate appellate courts, Court of Civil Appeals or Court of Criminal Appeals, and then it goes to the state Supreme Court. And then it can actually go, if you're in a state court case and you're not in federal court, it can still go to the federal Supreme Court after the Alabama Supreme Court. Now, each one of these levels, essentially, I don't want to say it gets harder to win. The standards are the same. But whether or not they're even going to look at your case at the Supreme Court levels, both the state Supreme Court and the, federal Supreme Court, the United States Supreme Court, they can say they don't want to hear your case. Now, the intermediate appellate courts do have to. They don't have a choice. They got to at least look at it. Supreme Courts do not. They can turn you down. What do they call it? Denial of writ?
Writ of certiorari.
Okay. Latin.
If you are...
Can you spell that?
Yeah, you spell that for me?
T-H-A-T.
Oh, okay.
Now, if you're going to do an appeal to the Supreme Court, you petition for writ of certiorari if it is an appeal coming from the intermediate appellate court. Now, if it is an appeal from, say, circuit court directly to the Supreme Court, that's different. You don't do the petition for writ of certiorari there. That's a direct appeal, and it has the same standards as if you were appealing to civil appeals or criminal appeals.
And that's because if it's anything over $50,000, right?
There's that, and then you got state agencies that have the appeal directly from circuit court to Supreme Court. Okay,
now I'm going to have a little fun with you because I know we got to get to at least one viewer question. What's a writ of mandamus? Oh, now I'm having a little fun with it. Yeah. Now we're having a good time.
Well, and we could spend a whole episode on a writ of mandamus, but kind of the thumbnail sketch of that is that if there's an order that you want to appeal from and it's not a final order, then you can file a writ of mandamus and ask the appellate court to order the lower court to see it your way. In other words, if I get a divorce case coming in and I feel that it's filed in the wrong county, now I file a motion to dismiss on account of improper venue, or in the alternative to transfer it to what I believe to be the appropriate county. If the court denies that, I can file a writ of mandamus to the Court of Civil Appeals and tell them why I think it should have been either dismissed or transferred, and let the appellate court tell me why I'm right or wrong.
And that's like lobbing a hand grenade, though, isn't it?
Right.
Yeah. Sorry, Sean, a viewer question. Sorry, Mickey. Viewer question. We got to at least get to one or two of them.
Yeah, let's get to a couple of them. So, real quick, what is one of the biggest mistakes you notice when people are trying to appeal a case?
A lot of times, it's missing deadlines. Now, if I miss that 42-day deadline on appeal from circuit court, we're done. There's nothing I can do on that. There are certain occasions that do allow for filing a motion to extend that time, but if I don't file that motion and I don't file that appeal timely, then that appeal's done. There's nothing else that can be done. Now, if, however, you've missed a deadline on submitting your brief, then there are certain occasions you can get an extension or file a motion with the court asking them to treat it as timely filed and give your reasons why, and then the court can grant or deny that.
Okay.
That's a big risk.
So
It is a big risk.
Uh-huh.
It is a very big risk. I make it very careful to make sure that I make those deadlines timely, so I don't have to worry about that.
Now, if someone starts the appeal process, can they present new information in the appeal that they didn't present in the original?
No, you have to present your reasons for your error. And in some cases, you actually have to preserve the error by filing a post-trial motion. And if you don't, that's waived. But even when you don't have to file that post-trial motion, you're limited by what happened at the trial court level, and you cannot present new evidence at all at the appellate court.
Now, that's something I say on the trial court level. We have to be very careful, because if it isn't in the record, by the time it gets to Mickey, it ain't going up on appeal.
Right.
That's generally the rule of thumb. Is you get it on the record by hook, crook, or explosive football. It don't matter. Like you know, do something.
Okay, well, one more question. So when someone starts the appeal process, how long does the appeal process usually take?
And that's the answer right there.
Yeah.
There's not a science to that. I will say that at the Court of Civil Appeals, they do have to give precedence to termination of parental rights cases, so those will go through a little bit more quickly. But in a civil appeals, other than that, sometimes it goes at a snail's pace.
Yeah, I think we're like the typical courts. We're just at the mercy of the courts and what their dockets look like.
Well, and like a big part of that too is, I mean, understand how big the record is. I mean, if you've gone through a 2 or 3 week trial, it's going to take them a minute to go through the transcript. People don't realize that whole transcript goes with your appeal. So everything that was said at whatever that hearing is or whatever that trial was is going down. And somebody's got to look. Sometimes it's a box, okay? Like it's a box.
Yeah.
And so they have to look through all of it, or they have to have a clerk do it as well. And so it's a much bigger endeavor than people realize. Now, when it comes to tennis stuff, it's a little quicker, I found, because they're basically going, okay, is there anything glaring in here, like something that's just never should have been said, never should have been there. Now, but the matters of law, the de novo appeals, those seem to be a much, much longer period of time, because they really have to look and say, was there a violation of the law itself here, not just a disagreement as to what testimony or a piece of evidence meant.
Well, thank you, guys. That was great information for our viewers, and I think the biggest key takeaway is that very fast deadline if you want to appeal something. Definitely get it in on time and talk to an attorney as well, of course. If you have any more questions about appeals or questions in general that you want us to answer on the show, please send those in to legalhelp@jmmtlawfirm.com. We love to hear your questions and answer them. And as always, we thank you for tuning in. We hope you have a great week. We'll see you next Sunday.
Thank you.
Thank you.